be able to see that one person is missing from
Who is not there?
That is the first respondent, Alan Sheikh.
Alan Sheikh is not here.
Yes, then you'll be able to make an application on that.
Yes, I will.
Zubeto, my colleague Mr. Omondi.
Appearing with
Mr. Omondi,
Mr. Omondi.
for the first respondent.
We have let us pass the record straight. Because it's in the matter.
That matter is one of the agents. I shall be assisted by
Second. You are the Karanja.
Yes, Mr. Karanja, for the second part of the press conference.
Where is Morelli?
6th and 7th respondents.
What does it mean? How do you know? Mr. Roberto, Omondi, and
Into the matter for which we appeared before the Honorable Court on the 25th of March 2024, seeking for 21 days, but we were given 14 days for the completion of those investigations, and forwarded the file to the ODPP via a letter.
Just a minute. And forward
the file for advice to the ODPP.
Yes.
The
By the letter.
Homicide Division. I have also Inspector Frederick Kossen, who presented that application on the 25th of March 2024. If the court would wish to hear from me, it's before court. That is all. Those are the directives of the ODPP. That's of this meeting. So, in our case now, therefore, the IO is here.
Currently, I'm attached at DCI performing general investigations. Your Honor, I wish to close the miscellaneous application dated 25th March 2024, which I saw before this court. That I did the investigation and forwarded the file to the homicide. Who then forwarded the same file to the ODPP. So, Your Honor, I wish to close the application. Miscellaneous application. That's all, Your Honor.
Application. I observed the application both the PPP and my colleagues. The application is dated on the 7th. The application is to have this amount of vehicle belonging to the We have attached a copy of the logbook. The same was detained for purposes of taking photographs. That motor vehicle is also released. That is KDK 788. Very well, Your Honor. Your Honor, that application was filed through the e-filing platform. I don't know whether
you can read that application there. We do not have the application.
I had served it also on the court assistant. I don't know whether.
Application is not in court. So I think the best way you can handle it, if it is part of the
Correspondence.
The issue before what is
Those are.
Or helping court create a jurisprudence. You know, that the reason why I'm saying, and the application before this court was on the custody of the respondents. Your court ordered that they be brought to this court today so that you would hear from the prosecution side on what they have decided. However, Your Honor, you have seen the pressure that I've had since morning when I came before you. That even if they have preferred a charge, and there was an order of this court that they be brought to this court so that they would be able to explain to court whatever they found. You know, we find it quite amazing that they had decided on a charge and took him to a different court while we are waiting to hear the conclusion of the investigation. You know, the family of the first respondent would want to raise that they are so disappointed on how the prosecution have handled this matter. And also to go on record, Your Honor, is that on criminal justice system, it does not begin in court. It begins with the investigation. You know, you're being treated to a sham today whereby they want to explain to you that they've already done their work and preferred a charge. They have discharged other people and decided that other people are to be charged. You know, it is our submission today that this court has power and could have
there is no evidence. That is an injustice, Your Honor, that is irreparable, that cannot be remedied. We've not even had even an attempt to tender an apology. The homicide team, and I know this for a fact because my clients were contacted, the homicide team from Kiambu Road said after they conducted the investigation, there was not even the most basic of evidence. Yes. So let me. Yes. So let me. Yes. So the point I'm trying to make is this.
Your point is not
Yes. That going forward, that conduct should be condemned by the DCI, so that they stop undermining our constitution, Your Honor.
You cannot talk forever, Mr.
Thank you.
Just one thing to add, Your Honor, because I am.
There was an offense that was committed. The prosecutor did not just bring an application to court just for the purpose of wasting cost time or even deny the respondents their rights. An offense had been committed. We have to agree to that. And the police had the right to go and do the investigations, which investigations have been done. And respondent number 1, number 2 to number 7 have been found not to be culpable. Now, today, the same respondent number 1 was supposed to be presented before court in Kiambu to take the plea. It was not possible for him to be in court today, at the same time to be in Kiambu to take the plea. But if the court so orders, we can wait until they finish their plea, take a plea in Kiambu, and then we come and proceed and close this application. But that one, of course, will cause delays. As you can see, most of the advocates for the responses are not opposed to us closing our application. And I don't think there is any reason why this application should not be closed today. Because we have, yes.
Yes, let me, as I began, I say, as officers of court, we can help court create a jurisprudence. What I wanted to ask is that if they could have agreed today that they are charging a second court that we wanted to appeal, do we take this one to the other side, or this court had jurisdiction to hear up to the level where we are, that they were kept in custody, a report was brought.
Presented to court for closure of this file. If you insist, then we will wait until it's presented.
For your direction, because for this we are assisting even for the jurisprudence.
I get you,
yes.
where you're coming from.
If it's in your conscience and your discretion that you find that it doesn't hold any water, then we can close it. But if you think that if you create a jurisprudence, that the prosecution one day would not behave the way they've done today. I don't want to keep my brothers in pendants, awaiting that I am making a complaint. I am asking that this court can create a jurisprudence, that one day they will be warned not to do the same thing they have done today to another person, because we are helping the nation.
So what you're telling me is that this file should be closed.
Yes.
I am a charge.
We can present it.
Yes.
As criminal case number E011, I don't know whether you've been sharing alias high value. You have seen the charge sheet. Been presented before PMO.
Now that I have heard, and now I don't know whether he's already taken a plea the other side.
If you cancel this charge sheet, because I also
Yes.
just been given the same by Mr. Mutule.
We would agree principally that we close the file. Most obliging.
Hearing is now closed based on the prosecution's presentations in court, as well as the response from counsel for the respondents. So we are done with this file. We are thanked as official. It is in the application by they are treated as a...
No, they did not make a formal application. They just said they want to close. But I think for avoidance of doubt,
yes.
Could you kindly, could the record reflect, Your Honor, that you have discharged?
Hiyo watu ya makelele pia warudi hapa.
Let them be discharged. There was a custodial order. Your Honor, can that order that you made on 25th
just a
be
minute.
ordered?
Mr. Nganga, yangu imeisha. Nimemaliza.
Lakini wametoka, sio?
I thought we have been submitting. You want us to be in court throughout? Mupatia mawakili kazi ingine ya hii imeisha.
Joe.
Thank you very much. Thank you. Thank you.
Eddie, msikie bali.
Ni kweli.
Let's go.
Wacha nani
brief statement. As you are aware, they've just been released. So the previous time we were before court, that was on the 25th, the investigative agencies were accorded about 14. And then thereafter is when they would have charged, depending on the outcome of the investigation. But we are happy to report today that after the investigations, the investigative agencies forwarded the file to the DPP. The DPP actually recommended only one of them to be charged. The 6, including Joe and the team that is here, have been exonerated by the investigations. But what we've heard in court is that the prosecution intends to use the 6 who have been released today as witnesses. I think that is a much that we can comment on that matter today. Thank you. Got 1 or 2 questions? I think that would be sufficient. Unless there's a question.
What imeisha?
Yao imeisha, to put in plain language, yao imeisha. So whatever we had in court is that the prosecution intends to use them as witnesses. That is all we know. I think I have my colleague here also.
That even the decision to convert DJ and the team as witnesses is not a decision that has been made by the DJ. You know, there's a lot of misreporting. They wrote a statement regarding what transpired. They did not incriminate anybody. So please, let there not be misreporting that people have decided to buy their freedom by incriminating other people. The DJ and his team has consistently maintained the position that nobody was assaulted, nobody was beaten. In fact, as at this morning, when we heard that there was a recommendation that was sent to the DPP to charge, that recommendation was sent by the DCI without any consent of DJ and his team. So it is them who made that decision, right? So that thing of reporting that there is somebody who has decided to incriminate anybody else so that they can buy their freedom is nonsensical. And there cannot even be murder anyway. If people fought, there cannot be murder. The most there can be is manslaughter. Because if everybody were to die because of a slap, then everybody should be charged. Anybody who fights with someone and then that person ends up dying, does it mean that that person is guilty of murder? So investigations that has been done, we also do not even know. All we know is that today, unlike 14 days ago when we were told there was preliminary evidence, today there was no evidence. Today what happened is that DJ and the team were told by the court that we did not find any evidence, and that is why we did not charge you. And we said that 14 days ago. The reason why we were saying that even investigations were to happen, it should happen when these people are out on bond, so that we avert a scenario where people are held in wrongful custody for even a day or 2 days or 20 days or 14 days, only for the DCI to come and say that these people should be released. Our concern as lawyers is simply this: the injustice that DJ and the team has suffered for being in incarceration for 14 days, how will that be reversed? Of course, DJ and the team will be consulting with us. The law has now changed where DCI acts maliciously. Those specific individuals and those police officers and those detectives can be pursued individually, and they can be held liable because of infringing on the rights of DJ and the team, right? Because if we allow this to happen, you and I will not be safe. Because what would stop now someone from coming and telling my good friend here that I need to investigate this guy for murder, in the meanwhile, give me permission to hold him in custody for 14 days. If this does not change, we will not be safe. And I think there is a worrying trend, and this is a complaint we were making before the court, that we are not saying that the DCI should not investigate. But the reason why we say that investigation should precede an arrest is so that you do not have people who are innocent, all right, being held in pretrial detention like what has happened to the DJ and the team, only for the same people who came and say they have evidence to now come and say these people should go home. This is a worrying trend. This is a clawback. This is something that should worry every believer in constitutionalism and fundamental rights. Remember during Kenya, before we got the 2010 constitution, people, the special branch used to hold people in communicado without charging them. Why we gave ourselves this new constitution is so that you and I, when you are arrested, you are presumed innocent. Even if you've not been charged, before someone is committed to pretrial detention, there has to be very compelling reasons. The other day, we told them that you're saying that there will be interference with witnesses. Counsel, you remember us asking, our clients do not even know the identity of these witnesses. You're saying people need to be taken to Mama Lucy for mental assessment. What do you know what that meant? That these people are already guilty of murder, or rather we have found evidence of murder. How come today they've not been taken to Mama Lucy for mental assessment? It means a fraud was committed on the court. The DCI simply just had no evidence, and that is why they came to court. And I think something else, there is a malicious aspect to this investigation. The complaint is by DCI Kabete, where the deceased was working. The incident happened in Kikuyu. The DCI Kikuyu has no idea that there was an incident that happened outside their police station. How come all these investigations, when they were being done, they bypass Kikuyu police station, and yet there is a DCI department there? Until the homicide team, because I can confirm here and now that the investigations touching on Mfalme and the team was taken up through the intervention of the director of DCI by the homicide team at the headquarters, Kiambu, who now have conducted very thorough and independent investigations. And they have exonerated DJ and the team. It should not surprise you that when these investigations were being done, when the homicide team went to Kabete to even get the DCI there to take them to the scene, they say they did not even know the scene of crime. Can you imagine? People have been detained for 14 days, and yet the investigating detective does not even know the scene of crime. They had to go for my client in Rirota police station to take them to the scene of crime. So what is this that they were investigating? What is this evidence that they had to get people in custody for 14 days? It is wrong. And we are not saying this because we are defending DJ and the rest. It's because this constitution and the right to be released on bail and bond is to everyone. So that you do not have the police exercising vendetta. You do not have police exercising, operating maliciously, and having you and I incarcerated wrongfully, only for us, after 14 days, to be told that, I'm sorry, we did not find any evidence, go home. So what happens to the injustice that the DJ and the team have suffered? How do you reverse the injustice of serving wrongful custody for 14 days? It is wrong, and it should concern everyone, and it has to be condemned. It should be called out. Because there are few elements within the DCI who are violating the Constitution and being allowed to get away with it. All we are saying is that let crime be punished. Let investigations be done. But let investigations be done objectively and not maliciously with an intention to punish people, even when they are innocent. We came 14 days ago, we said there was no evidence. How come today they came and concurred with us? So why did they have to suffer custody for 14 days? Because I wish after 14 days they came and they told them, we are charging you. But how comes out of all these people, and even this particular person that they are saying that they are charging this morning, whom they did not even bring to court, there is nobody who has given any incriminating evidence against. In fact, we'll be waiting to see that evidence. Because they said that there is CCTV footage outside Kikuyu police station. We said there are no CCTV cameras. All right? They went to Texas, where that guy was drinking that previous night. They reviewed the CCTV footage there. DJ and the team were not even anywhere near that police officer. They did not even know he's a CID officer. They've reviewed that. How come they've not even seen, not even a single person who was assaulting that person? And now here we are being told 14 days, lock them in. It is wrong. It's a violation of people's rights. We have to call it out, and not because it touches on DJ. And I think it's important, even as we report this thing on social media, we are not defending DJ because it's DJ. We are defending DJ because he's a representative of all the 42 million Kenyans who are supposed to be protected by Article 49, which says, we presume you innocent until proven guilty, and you have a right to be released on bond. Because if they had released these people on bond, they would simply have come today and would be like, we did not suffer incarceration. Now that you did not find any evidence against us, we are happy to go home. But now here, you incarcerate, and then you tell them, go home. So what happens now that I was in because of your request? Who pays for that? Who addresses that injustice? That's why we are complaining. And that's why we are saying, going forward, DCI must operate within the law and must know what the Constitution says and must guarantee the rights of people even when they are doing this investigation. Punish crime. If people have committed crime, let them be punished. But innocent people to suffer custody for 14 days, when you say they had evidence, and then you come back and you say there is no evidence, and you don't even apologize to the court, you say, we are applying for the file to be closed. And then, people lista yao walikuwa ndani, si ndio? Others were Muslim, they could not even fast during the holy month of Ramadan. Others are mothers. Another one is even expectant. So who redresses that injustice? It is not about DJ, it's about all of us, and we have to be concerned because that is not what the Constitution says. But I think the people who are also charged with defending this Constitution, the men and women who are charged with defending this Constitution, must be bold enough to call out this conduct. Because the effectiveness of this Constitution is only as useful as the people who are charged with defending it. Because if casually we will continue entertaining these applications by DCI to incarcerate people, only after 14 days to tell them to go home, nobody is safe. Nobody is safe. Thank you, guys. Yes, the DJ can file a constitutional petition for damages against the officers who maliciously and without any evidence got the incarceration order. Yes, so we shall be advising the team to consider taking out a constitutional petition for that purpose so that they can have their rights vindicated. So the matter doesn't end here. Here it's only the issue of the police. But insofar as the infringement of the rights of the DJ and the team is concerned, they have a constitutional remedy, and we shall be advising them accordingly on the route that they should take.
It is a sad day. Let me first begin by introducing myself. I'm Otiende Omondi, appearing in this matter for the first respondent, who is Alan Ochieng, also known as Think Today, is that you've seen the sham that has been done in this court. Because, remember when we were here on 25th, we had seen what they had already done. There has been a social media campaign raised by the other respondents and the police at large. Initially, you would see that the first respondent, Mr. Alan Ochieng, also known as Balo, was characterized as the bouncer. Therefore, at that particular time when we saw that, we raised an issue that when you characterize an hyper as a bouncer, then definitely you've already skewed the investigation that you do. It is also important to note that criminal justice system does not begin in court. Many people only come to court to cleanse those who are culpable. First of all, let me say that I'm very sorry for the family of the late, is called who, the officer? The family of the late, that he met his life untimely, but we are afraid that he will never get justice. Because what you are seeing today is already a sham. You are being treated to a sham as a nation, whereby you would see that those who would help the family of the late to get their right and justice are already released and have already been turned to be the state witnesses. Therefore, we are afraid that when you talk of public interest, it does not mean that you arrest anyone and then you treat the public with a sham, and then you release some people and you look for. First of all, it is important to note that one who has been charged today is charged because of his poverty. He comes from Kibera. That was what we can speak. It means that if you don't have money in this country, then even investigation does not stand with you. That is what we want to raise. And with that, I would let the other council also to speak before I invite our senior.
Ladies, a moment. We wish to reiterate this position as the team for the representation of the first respondent. My name is Ms. Angano, appearing alongside my senior here. But what we would want to say is that we put it in record for the entire country, for the entire justice system, that the letter and spirit of the Constitution under Article 49 should be adhered to everyone. And the framers of our Constitution did not arrive to this decision and to this article for specified person. Our client, who has now been left in the course of this justice system, has been put in that situation because of so many factors, which we'll probably dealt with them later. But what we really want to put across in this moment is that we need to adhere to the letter and spirit of the Constitution. Let us not be swayed by the matter of public opinion and public interest. Let us push the Constitution to the core, and whatever is the outcome of this situation is that we are going to push and to make sure that we serve justice, not just to our client and to the victim situation, but for the rest of the country, so that each and every one of us can be able to know that whenever you have an issue, you are being put across to the proper justice system. My senior has reiterated that the criminal procedure is not just the court situation. The criminal procedure starts with the complaint, then there's the most important investigation point that the police, the DCI, and all the required entity are supposed to adhere to, so that they can be able to come out with an investigation that can be able to be put across court, so that this person can put the defense and be able to be charged, and each and every one of us will look at it from the face of it, that indeed this person was gone through the criminal justice system. But if the process has been flawed, me and you know that we cannot say that the decision that will be achieved at, or rather reached at, once a flawed system has been occurred, can be good. We know all the situation, we know all the circumstances, and we are going to team up to prepare and to make sure that this process has gone through the required situation, and we come up with the proper justice system for both parties. Thank you so much.
The first respondent is concerned by giving a disclaimer. This matter is still very much alive, and we are doing this within the context of giving information to the public, because then information must circulate. And we want to encourage the media. You had picked this issue from the get-go, when all the 7 parties were presented in court as respondents. As you're aware now, 6 of them have been discharged. We are going to expect the media to give this matter the same attention it was giving before, when we had the 6 respondents. I say that because we have seen a pattern that has been orchestrated. In that sense, I associate myself with what my colleagues have said. In the first instance, when our client, now the accused person in this matter, was arrested, he was blatantly beaten up. And he was the only one who was beaten up among the 7 respondents. Secondly, he was detained separately at Kabete police station, while the other 3 were detained at Mudangari, and the other 3 detained at Riruta. So we already saw that there was a common thread to isolate our client, the accused person in this matter, and place the blame and the responsibility on it. And you can see also, it was also circulated around that he was a bouncer. Now you have seen, if you've heard about the information sheet that has been presented in court, he has been properly captured as an alias, the hype man. He has always been a hype man. He is not a bouncer. And we want the record to be set very clear as far as this issue is concerned. We shall continue to evaluate the evidence that the prosecution is relying on. As you've seen, the prosecution has already even contradicted itself here. while it is still sticking on the phones of the so-called witnesses. It is still sticking on the vehicle belonging to the so-called witnesses, and at the same time, alleging that these are state witnesses. So we can already see a lot of contradictions in this matter. Of course, we do not want to canvass this matter in the public domain. We respect the process. Shortly, we are going to rush before the High Court, Superior Court in Kiambu, where our client will be arraigned as far as the matter, the plea taking is concerned, and we shall continue to ensure that we address the issues on a particular way. But we have confidence in the judicial system. We are aware that ultimately due process will be followed and our client will receive justice that he so deserves. So thank you very much, and we will continue to engage. I don't know if our family members want to.
Mimi ni mtetezi wa haki za kibinadamu na mwanaharakati. Nataka kutoa pole zangu kwa familia ya mwenda zake, lakini nahofia sana kwamba inaonekana kwamba hatutapata haki. Tayari kuna dhana potovu ambazo tumeona kwenye koti hii. Tumeona kwamba tunabaguliwa. Ala ni mtoto ambaye nimemlea wakati mama yake aliaga. Ni mtoto ambaye amekuwa kwa mkono ya jamii. So tunaona kwamba tayari tunabaguliwa kwa sababu sisi hatujiwezi. Sisi hatujulikani. Dhana la kusema kwamba Alan alikuwa bouncer ambayo imekubaliwa na kila mtu, ili hali tunajua sisi wote mpaka vyombo vya habari vimempeleka kwenye station na hakuwa bouncer. So inakuwaje leo kwamba yeye ni bouncer? Ya pili, wanashikwa wote. Katiba ni wazi kwamba you are not guilty until proven. Mnashikwa kwa sababu mnashukiwa, alafu wengine wanateuliwa na wenzao. Yeye anapelekwa kwenye cell tofauti, wale wengine wanapelekwa kwenye cell tofauti. Nataka pia kusema mimi najua haki zangu msingi. We have right to information. Mimi kama mtu ambaye niko karibu sana na Balo, nafika hapa nikitarajia kwamba atakuwa arraigned in court. Kisha nasikia sijui amepelekwa wapi, na hauliza hakuna mtu ananiongelesha, hakuna mtu ananipatia majibu. Ninasikitika sana. Nasikitika sana, na ni bayana kwamba hapa kuna ukora, kuna utapeli, lakini sisi kama jamii na wanaharakati hatutanyamaza kimya na hatutaacha maovu itendeke tukiona. Tunaomba haki itendeke kwa familia ya mwenda zake, haki itendeke kwa Alan, na hata wale wanajiweza kwa vile wako na fedha pia wapate haki. Kama mtu amefanya makosa, tusiangalie akona nini, jina yake ni gani, akona pesa ngapi. Alan ni mtoto wa jamii, hatuna uwezo mkubwa, lakini tutatumia sauti zetu kueleza dunia nzima na Kenya kwamba tunataka haki kwake Balo. Asanteni sana.
Thank you so much. Thank you so much. Thank you.
Okay. So my name is Jacqueline Cohen. We are here as family and friends of the deceased officer, Inspector of Police, Felix Kintosi. We are here to follow this matter, and we have seen that we are not likely to get justice, because when the investigations, when the case is just beginning, and we hear that 6 of the 7 suspects have just been freed, and yet for people, it is important for people to know that we spoke to our kid before he died. He did not die immediately on the scene where he was beaten up. He was beaten up, arrested by police, taken to the cells, released the following day and taken to hospital. And therefore we spoke to him. We actually know that he was beaten up by more than one person. And that the person that they are saying is the key suspect is a worker of one of the people who have just been freed. The officers, the police officers, were actually witnessing as the officer was being beaten up. And therefore to us, this is not the way to go. We feel like so much is being hidden, and justice should be seen to be served by the courts in Kenya, because we want justice for our kin. We want the death of our brother unraveled, and we really are seeking that the courts, every person that was involved in his death is, brought to book.